Okay, hello again, everyone, and good afternoon, and thanks for joining us today for today's webinar with Robinson and Cole on current trends with DOJ enforcement investigations and how to respond if your lab receives a knock at the door. I'm Alex Mitchell, and I'm a communications manager with the Lighthouse Lab Services marketing team, and I'll be serving as your host today. We're fortunate to have two expert speakers and healthcare attorneys on the call to dive into this topic with Robinson and Cole. But before we introduce them, I'm going to give you a very brief overview of what we do at Lighthouse to be able to help labs and hold these webinars for free. Lighthouse is a trusted partner of medical laboratories across the country, and we assist with everything from recruiting and staffing to revenue cycle management and payer contracting. Our team consists of more than 150 professionals, industry experts, and including more than 12 PhDs. Whether you're looking to start or grow your lab or your current business, we offer ways to accelerate your lab's success. I'm going to quickly touch on a few housekeeping items here. You can reduce your chance of any lag or buffering by closing any apps you might have running in the background. We're going to be recording this webinar and it will be automatically sent out to everyone later this afternoon at the address you registered under. And you can also go ahead and download the slides if you'd like. They're available in the handouts section on the chat tab. There's no need to wait until the end to ask questions. We will be doing a 5 to 10 minute Q&A as time allows. But if you have questions during the live presentation and don't want to forget about them, go ahead and drop those in the Q&A section and we'll try to respond to them at the end. And if we don't get a chance to touch on your question, we're going to have multiple ways to get in touch with ourselves and both the speakers from Robinson and Cole today. So you can go ahead and fill out that form when they're pushed out and you'll have a chance to follow up with them. And we also run polls during the webinar, just a form of engagement, a chance to sound off and get a sense of some of our audience's feelings on the topic. They're completely optional. If you'd like to participate, feel free to respond. And if not, just X those out when they cross your screen. I'm going to briefly introduce both of our speakers today before I hand it over to them. First, we have Danielle Tangorre. Danielle has extensive experience counseling clinical laboratories, healthcare providers, behavioral health providers, hospitals, and other healthcare entities to navigate operational and compliance issues and assist with business transactions. Danielle takes a holistic approach to help her clients to work to achieve their business goals within the regulatory maze of federal and state laws. In addition, Danielle regularly advises clinical laboratories and other healthcare entities with respect to federal and state fraud and abuse laws, and represents clients before federal and state agencies related to payment disputes and investigations. So thank you to Danielle for being here with us today. I'd also like to introduce Edward J. Heath. Ed is the chair of Robinson and Cole's Business Litigation Group and the co-chair of its Government Enforcement and Corporate Compliance team. For nearly 25 years, Ed has helped businesses across the globe resolve their disputes with governmental and private parties. He routinely advises healthcare organizations, laboratories, manufacturers, financial institutions, and other entities responding to civil and criminal investigations and enforcement activities, including those with respect to federal and state fraud and abuse laws and the False Claims Act. He regularly represents clients before federal agencies such as the United States Attorney's Office, the Federal Bureau of Investigation, the Department of Health and Human Services Office of the Inspector General, and the Centers for Medicaid and Medicare Services, as well as various state attorneys, attorney generals, and other administrative agencies. As a result of his extensive experience, Ed is often called upon to conduct internal investigations for healthcare organizations and other businesses, and to provide guidance on matters of corporate compliance and litigation risk. Again, thank you both to Ed and Danielle for being here today, and I'm going to go ahead and hand things over to Danielle.
Thanks, Alex. Ed and I are very happy to be here today, and hello, everyone. We look forward to talking to you today. Just as a quick housekeeping note, as you are probably used to by now, I'll just leave this here, but this doesn't constitute legal advice, and we're not creating an attorney-client relationship. We are just here to give you general advice and some insights today, but we look forward to talking to you. So today we're going to take a little bit of a different approach. hopefully, and we're going to focus less on the technical aspects of the laws, but we really want to talk about compliance and business practice through the lens of enforcement. So what that means is we're going to talk about healthcare enforcement and the enforcers. We're going to identify some trends for you and compliance considerations and red flags that you should be on the lookout for. Then we're going to talk about responding to typical investigations and some tips about getting ahead of the knock at the door. No one wants to think about the government coming knocking, but in the event that that happens, we want to give you some insights and also of how to handle that, and also to talk about ways to avoid that. So at this juncture, I'm going to turn it over to Ed.
Thanks, Danielle. All right, so let's start with the concept of what do we mean by enforcement. We're really talking about investigations. Investigations by government personnel into potential civil or criminal violations of the law by others. They do it through seeking documents. They do it through gathering information. They do it through witness interviews. They do it through, formal testimony in court. They do it through audits and the like. And what is the investigation aimed at? It's aimed at a resolution. There's an end game that the government has, right? What are they hoping to do here? Well, ideally for the party on the other side of the investigation, it ends with the government closing its matter. That unfortunately doesn't always happen. More often than not, what the government does is it tries to move to some kind of a formal resolution. And that formal resolution, that can take the form of an agreement that would require limitations on what you can do. It required payment of money. It could require restitution. I'm sorry about that. I've got something in my eye here. It could require something as extreme as a guilty plea. Finally, it could mean if an agreement can't be reached, that there's court action. It could be civil, it could be criminal. Civil means payment of money. Criminal means, unfortunately, prison. And yes, in the healthcare fraud context, individuals do end up going to prison. So the stakes of enforcement investigations can be high. Now, who are the enforcers? Well, it could be federal, it could be state. And you're more likely to encounter enforcement at the federal level than you are at the state level. And at the federal level, we're talking about the Department of Justice primarily, which consists of U.S. attorneys' offices. It consists of the Federal Bureau of Investigation. It could also be, as Alex alluded to in the introduction, Health and Human Services Office of Inspector General. It could also be CMS. Most likely at the federal level, you're going to run into a collaboration of those agencies. Now, specifically, when we talk about the DOJ, what you're most concerned about here is the healthcare fraud unit. And that's a unit within the Department of Justice, and it employs a strike force model that they use to investigate healthcare fraud across the country. There are 16 different strike forces around the country, and there's also something that's got the very eye-catching name of the National Rapid Response Strike Force, and that's based in Washington, D.C. That National Rapid Response Strike Force tends to handle multiple jurisdictions. So when there's a potential fraud that spans a number of different states, that national office steps in. And really the strike force model, it employs a collaborative approach. So you have lawyers from the DOJ, agents from the FBI, agents from HHS-OIG and CMS, even agents from other agencies such as the DEA, the IRS, the FDIC of all places, Postal and Veterans Affairs. So it's a very sort of collaborative federal approach. Now, if you're talking just about HHS-OIG, then their investigations tend to come about as a result of typically routine audits or data analysis and trends that they conduct. They do Medicare and Medicaid compliance reviews, but also like DOJ, their investigations and their audits can be triggered by complaints or by whistleblower reports. Can't forget about whistleblowers in this context. Now, on the state level, you're most likely to encounter the Office of the State Attorney General. And typically within most state AG's offices, there's something called MIFUCU, the Medicare Fraud Control Unit. Those are the lawyers and investigators who really focus on healthcare fraud in most states. And so how are you likely to encounter the enforcers? Well, there are a range of both formal and informal measures that the government uses. they're all pretty unsettling, and they run along a spectrum from informal, as I said, to formal. Now, the most informal approach that your investigators can take is simply showing up in your lobby. They appear there and they want to talk to you. They don't have any kind of compulsory process in hand. They're just there to talk. So, imagine this, you're sitting at your desk and you get a call from the receptionist who says, there's 2 FBI agents here in the lobby and they want to speak with you right now. For most people, whether you believe that you did everything above board or you've got some questionable practices, that's a moment of extreme panic when that happens, right? You're sitting there wondering who should talk to these people. What should I say? What are they going to want? What's going to happen? Are they going to haul me off in handcuffs? Those are the things that runs through everyone's mind in that moment. And it's a pretty scary moment. And what we're going to talk about a little later today is what to do in that moment. You might be surprised to learn that even though Danielle and I are lawyers, we're not going to say to you, you absolutely have to call a lawyer in that very moment. No, when they come in for an informal request or to drop off a different form of compulsory process, we're going to give you some advice on how to handle that on your own, at least to get things started. But it is a nerve-inducing moment. Another way the government can come to you is they can appear, and again, they typically serve these in person. It might be a letter that asks for information, or more likely, it's something called a civil investigative demand, or CID, or a subpoena. I'm sure most of you have heard of subpoenas, and you know what they are. They're an order to produce documents or information under penalty of law. It comes from the Latin sub, meaning under, pena, meaning penalty. It's not, in this context, it's not going to be an order issued by a court. It's signed off on by some government agent. And that's true whether it's a subpoena or a CID. And in a moment, we're going to put up a sample CID for you to look at. The government may come to your offices or may send out a letter request or make a phone call asking for a formal interview. That would be a situation where they ask you to come down to the government's offices, typically to the U.S. Attorney's offices. And just so we're all on the same page, when I say the U.S. Attorney's Office, that's the branch of the Department of Justice in your state where the federal prosecutors work. They can be criminal prosecutors or they can engage in civil enforcement. But this formal interview request is typically made through DOJ, and they're going to ask you to come into one of the U.S. Attorney's offices and sit there in a conference room with federal prosecutors or federal lawyers from the DOJ on the other side of the table, along potentially with a number of agents. There's not going to be a court reporter there typing everything down, but they're going to be taking very detailed notes of what you say. And as everyone knows, whatever you say can and will be used against you. Now, the most formal investigatory measure that the government has at its disposal, at least at the federal level, is the search warrant. Again, this is a concept you're probably familiar with through movies and TV shows, hopefully not from personal experience. But the search warrant, unlike the other things I've talked about, is a formal document that's issued by a court. So the agents have had to go to a court, go to a judge, and convince that judge that there's reasonable cause, that there's instrumentalities, evidence of a crime in your possession. And so they get an order from the judge to search a very particular area, which can be your entire offices, to look for some very specific things. And they come to your offices and they show you the warrant, and there isn't anything you can do to stop them from coming in. They come in and they're there to seize information. Now, as I'll get back to in a few minutes, there are some steps that you can take to best protect yourself in the event of a search warrant. But I would never advise you, and no one should ever advise you, to try to bar the government from entering your premises if they have a search warrant in hand. As I said, we'll come back to some of those specifics a little later on. But before we do that, I want to put on the screen an example of some CIDs, some civil investigative demands, issued by 2 different offices. And we'll give folks a minute to look these over. And of course, they're in the PowerPoint, so you have a chance to look at them more thoroughly. These are not involving any of our lab clients. We didn't know if we were going to have any of our clients in the audience or if they would appreciate seeing their CIDs, even with redactions, put on screen. So these are CIDs from other industries. But you'll see here, they look like letters, and they direct the production under law of certain documents and information. And one of the things I'll say now and I'll say later is it looks like a letter. So it may feel a bit informal, like it's something that you have an option to comply with, or you can take your time, or, oh, it looks like it's such a burden, I'm going to stick it in a drawer and I'll come back to it and I'm not going to worry about the deadline. Please don't let how informal this might look leads you to think that this isn't a very serious action by the government. Some agents sat around and said it's important to an ongoing civil or criminal investigation that they have this information or documentation from you. And so this is a very formal and very serious request, this kind of CID. Next example that we have for you is of a search warrant. Now, obviously, this one is also not from any lab client. It's actually from President Trump's home, but it gives you a good example of what a search warrant is likely to look like. They tend to not vary from this. In the federal system, this is a form. So if there are federal agents at your office and they're handing you something that doesn't at least reasonably look like this, that may be an issue. May not be a search warrant, may be something else. But this is generally speaking what a search warrant should look like. And you can see there on the screen, they've got a case number, they've got an in the matter of here, and they have a search and seizure warrant heading. And then as you go through, you'll see a variety of signatures, including a judge's signature. If you look at the left side of your screen near the bottom, you'll see the judge's name typed up, the honorable judge there, and you'll see a signature above that. And then if you actually had the warrant in hand as you went through it, you'd see an attachment A, which identifies the property to be seized and the property to be searched. And so that those attachments A and B will appear in the warrant because the agents have gone to the judge and said, this is where we need to go and this is what we need to look for. Now, as Alex alluded to in the introduction, I've been doing government enforcement work on the defense side for over 20 years now. And in that time, I've encountered a number of very common misconceptions about the way that folks approach a government investigation if you're in the private sector. And of course, there's a lot of sort of misunderstandings about the way the government works, and I can't cover all those today. But these are the three that seem to come up most often, particularly in the healthcare context. The first one is, well, it's right there. It says that terrorism, drugs, and organized crime are federal enforcement priorities, and healthcare fraud isn't. In other words, people think the government, they're not going to invest a lot of time into looking into, whether or not I'm following all the rules with respect to these claims that I'm making or these tests that I'm conducting. Nothing could be further from the truth. I will tell you that healthcare fraud enforcement is as much a federal priority as any of those three very serious matters listed here. Absolutely just as much. And they typically do it through, False Claims Act investigations. And just to give you sort of a sense of the volume, for fiscal year ending September 30th of 22, so last year, the settlements and the judgments under the False Claims Act that the federal government recovered exceeded $2.2 billion. That's billion with a B. That was just for that one fiscal year. Now, there's a lot of different grounds on which the federal government can bring a False Claims Act, a lot of different industries that they can reach out to. And so that $2.2 billion figure is reduced somewhat in the healthcare context, but it's only reduced to 1.7 billion. So you can see that more than the majority of the federal healthcare false claims recoveries were in the healthcare context. So it's a critically an important priority for the federal government. Now, the next major misconception is either we can or we can't trust the government. What Alex was kind enough to do is put together a little poll to help us out at this point. So Alex, if you could run that poll.
I went ahead and pushed it live, Ed, so it was running while you were talking.
Oh, great. Okay.
Yep. Right now, I don't think I have the results on so that you and Danielle could see them. Didn't want it to be distracting, but 53% said no, we can't trust the government to have our best interests at heart. 32% are unsure, and 17%, I'm sorry, say yes.
That's
numbers
great.
are adjusting a bit live.
That's great. That's great. And thank you all for taking the time to respond to that poll. As you can see, there's a pretty broad diversity of opinion. And the short answer is, in my experience, it's a little bit of both. There are a lot of government agents I know, whether they're lawyers or they're field agents or administrators, who really come into the job with the best intentions of fairness and impartiality and just trying to get down to the facts and absolutely do the right thing. And those folks you can trust. On the other hand, everyone in every federal agency is just like Danielle and me and all of you. They're humans, and what they bring is their baggage, their biases, their experiences, their office agendas, and the like. And so the truth is somewhere in the middle. It's sort of a trust but verify context. You can't absolutely trust that the government is going to come in and be looking out for your best interest under any circumstances, nor should you conclude that the government absolutely can't be trusted and you have to circle the wagons and fight them on every inch of everything that they ask for and everything that they want to do. It's somewhere in the middle. And having that perspective will help you significantly if you find yourself to be the target or subject of a federal or state enforcement investigation. Having that mindset of I've got to take this step by step, and I've got to be measured in just how much trust I'm going to extend to the government. But I like that the we can't trust was a very high number. It's good to see that healthy skepticism out there. The last misconception is we can either outsmart or outspend the government. And I've learned that it's not the case. I know, some of us who've been around long enough still have echoes of the OJ trial in our mind and how he had this big legal team and he sort of bullied the government. It doesn't really work like that, particularly at the federal level. You can't really outsmart or outspend them. First of all, they tend to be experts in this subject matter, even more so than you are. They've seen the schemes. They know the tactics of those they pursue. All too often, I have clients who they're sitting at their desk coming up with an idea that they think is going to work, that they think the government's not going to figure out. And then ultimately, fast forward 2 years later, we're sitting in one of those formal interviews and the client has to explain what they were thinking. And they realize, out loud in a room full of people, this really doesn't seem like a good idea. And I really thought I'd get away with it and the government wouldn't figure it out, but they did. Because remember, the government has far greater resources than you can even think about, than you can even conceive until you've been through one of these investigations. And what's even more surprising is the amount of resources they'll dedicate to one of these investigations. The number of people, the amount of technology. You might think little old you isn't a big enough deal for them to dedicate more than one guy to go out and ask questions. But you don't know their office's agenda. You don't know where their priorities are. Your case may be the one that they decide to use as an example to send a message to the rest of the industry. And when they decide to do that, they put significant resources, far greater than the amount of money at stake. I had a matter years ago where there was about $20,000 at issue, and the government probably spent $500,000 on the investigation because they thought it was so significant what was happening, and they wanted to use it as not only a test case, but an example, so that they would get a settlement and they could use it as a message to the industry. So there were dozens of agents on that case. The government also has far greater access to data than you can consider. Odds are, if they're investigating you, they're going to get your data. They're going to get your email. They're going to get your text messages. They have the ability to use wiretaps to listen to your phone conversations or put, what we all think of as a classic, bug into a room. I've had cases where they put bugs in rooms, in hotel rooms, in restaurants where they know that where the targets go to have their lunches or their dinners. And as I said, I've seen them where they put it in cars as well and to listen to conversations there. And of course, others may have talked to them about you. There may be whistleblowers, there may be cooperators, there may be disgruntled former employees, there may be vendors who are pinched by the government and feel the pressure and decide they want to trade up. And remember, the government does have extensive pressure tactics at their disposal. There's a lot of things that they can do to put pressure on others and put pressure on you. One example that Danielle and I have talked about is, issuing a Medicare suspension based on credible indicia of fraud. So, you get that suspension and you can respond to it, and the government's supposed to respond per statute within 15 days. But in reality, they may not. They may take longer, and their review time could go on for months, if not years. The discretion they have is very broad. So during that time, you're not having revenue come in, and you need to exhaust your administrative remedies. For those of you unfamiliar with that concept, when there's an administrative agency proceeding, before you can go to court, the law requires you to exhaust your administrative remedies, i.e., let that administrative process play out. So while the government is not responding to you, to that suspension, there's no revenue coming in the door on those claims for that work that you're doing, but there's also no final decision from the agency. So when that happens, you can't even go to court. You're sort of in this purgatory, or depending on your financial circumstances, absolute hell to be in. And then after that, if a more formal investigation is launched, your revenue is not coming in, you don't have the revenue to engage counsel to defend you. So there's, again, as I said, there's a great deal of pressure that the government can exert on you in these circumstances.
Thanks, Ed. I think that's all really great information, and we want to spend a little bit of time talking about some of the trends we're seeing, where there might be someone showing up at your door, and hopefully not. But we try to track all indictments and settlements and plea agreements, etc., in the laboratory space, and collectively review those and identify trends. And I tried to distill down into three main trends that I've been seeing over the past year. While a lot of these are not necessarily new, they are where we're seeing a lot of the enforcement action right now and getting most of the news press. So I wanted to spend a little bit of time just talking about three of them. The first one are telehealth arrangements. You probably have tired of hearing about this. There's over the last couple of years, there's been nationwide coordinated takedowns with this. It includes all the healthcare enforcers, and it involves not only clinical laboratories but DME and pharmacies and things of that nature. But it was so it's been such a focus of the government that they've come up with these graphics, right, like we see on the right side of the screen. But more importantly, last year in July they issued a special fraud alert. Special fraud alerts are not that common. The last one in the clinical laboratory space before this one was in 2014. So you can see that they're used pretty sparingly. So to me, that signals that this is very concerning and a focus for them. With telehealth, we've seen, just with the prevalence of the pandemic, more and more providers using telehealth. So there's absolutely some kosher agreements where it's okay, but at the same time, with the prevalence of telehealth and the shift in business relationships during the pandemic, it led to new schemes and some potentially problematic ones. And then with the public health emergency ending in May of this year, the rules around telehealth have changed again. And so it's really important to be aware of that and how that impacts you as a laboratory. But I want to focus on the special fraud alert for a few minutes. You guys have probably heard about this, but they took the time to identify red flags. And some of these are common that you've heard about in the laboratory industry, but this is what they said, the government has deemed to be red flags. And I'm not going to go through all of these, but I think, there's a couple themes that we can pull out, right? There have been indictments and obviously a red flag here from the government that there's not a physician-patient relationship between the telehealth provider and the patient, and that there's just this routine sign-off on ordering laboratory tests. So there's not a determination of medical necessity, which is another trend we'll talk about, but just kind of a mass ordering of laboratory tests. We've seen a lot of enforcement action in this with genetics in particular. And so, this has been marked as a red flag. Some of this came from use of health fairs or door-to-door knocking, and trying to take advantage of Medicare patients, at least from the government's perspective. They've earmarked other ones about telemarketers and the relationship with telemedicine companies, and only furnishing one service. So, for example, they only prescribe genetic tests, and there's just a suspect indication there that maybe it's not medically necessary, right? Like maybe it's just a rubber stamp, and that's not what the government wants. They want a determination. So, one of the recent cases that came out was about genetic testing, and it was alleged that the laboratory billed Medicare without valid physician oversight, and the orders were obtained from marketers, right? And they were really the ones directing where the samples went, and there wasn't really a physician involved. So there was a big question of medical necessity, all within the telehealth arrangement. The next one that we're seeing is a trend about consulting and marketing relationships. Some of this can be related to, we've seen related to ECRA. The government has alleged that, marketing contracts that allegedly fall within the ECRA safe harbor of being flat fee are actually sham agreements and are really, percentage based for volume and value and are just so egregiously high that they can't be fair market value. But then there's other ones, right? Relationships between independent laboratories and hospitals has been a focus. There's been a recent case talking about improper payments of administrative and consulting fees and the relationships. There was also another case with allegedly improper incentives paid to physicians with their relationship to hospitals and the use of the hospital for testing. And then there's also been cases discussing reference relationships and pass-through billing and what those should look like and what they aren't supposed to look like and whether they're meeting the requirements, sometimes meeting the 70/30 rule, or if they're actually properly structured in the first place. And then there's kind of a general catch-all about whether, it's been papered over to really, and whether it really discusses the services, whether the contract makes sense, right? So at the very end of this, you can write a contract, but it has to make commercial and reasonable sense. And that's one of the prongs under the anti-kickback statute, is that you have to kind of think back. Does this consulting marketing agreement, for example, make sense? Is the services they're providing actually what the laboratory needs, or is this covering up some greater relationships amongst multiple entities that really doesn't make sense and is just a disguise? So you also have to step back and look at those contracts and what they're trying to do, and that's one of the themes we're seeing, and that also ties into the telehealth and what those contracts amongst all the parties looks like. The final trend is medical necessity. So you guys have heard about this. You probably know about the Boston Heart case, but medical necessity is one of the major focuses right now that we see from the government. So they're focused on large panels, right? So we see this in toxicology. We saw that years ago. We see it in UTI cases. We see it in genetic cases to some degree, but more in the tox, UTI, molecular space. As always, there's always a question about blanket orders or routine standing orders. One of the big things that keeps coming up is requisition design and whether that leads to large panels or is otherwise leading to questions about whether the tests are medically necessary and whether you're giving the physician the autonomy to make the decision. Medicare also changed their signing requirements for requisitions a few years ago, and so there's a big issue about requisitions not being signed. Sometimes that has led to whether the doctor's actually involved, and going back to the physician-patient relationship that we also talked about in telehealth. Common themes also are too frequent testing, and a big one that we're really seeing focused on is whether the testing is actually used in the treatment of patients, right? Whether it furthers the treatment plan. So we see this commentary a lot in the comment about genetic testing, right? Like, does it make sense for this person to have the genetic test? Does it actually provide clinical utility for the doctor to know the answer to this question? They already have cancer. Do you really need a cancer genetic test to tell you the likelihood for other things? Or, do you need testing for that particular condition? Or for all of those conditions, are you ordering too large of a panel to rule things out? Like what makes sense? And then we also saw with COVID, which is still going on, the issue of bundling of tests. And, there was an OIG data brief issued in December of 2022 and a report in mid-December that questioned, the billing of COVID-19 with respiratory panels and bundling. That's just one example, but they, Ed mentioned data analytics. That is huge, right? All of these go to this, and particularly with medical necessity, the government is leveraging data analytics. And you can see this most articulated in those reports and briefs that I just mentioned that were issued in December 2022 by the OIG. I mean, they looked at tests and they're giving you stats. They identified that 378 labs billed Medicare Part B for add-on tests at high levels compared to over 19,000 other labs. Like, they're looking at test and volume and where you lie in that. They also issued a data brief showing the increase in testing and the cost for it. And so they're tracking that. For example, they tracked that Medicare Part B spending on genetic tests increased by 56% in 2021 compared to previous years. And it went up by 1.9 billion. So they're looking at these and they're leveraging, and they're also utilizing data analytics to then say, hey, maybe there's a suspect here. So we're going to refer it over to CMS, to DOJ, to all of these agencies because there's a question. Or if you ramped up testing so exponentially, that's going to set off some flags and, be a cause for concern from the government's perspective. And they're going to look at that and see where you lie. And then that leads us to, them using those tactics and informal and formal requests that Ed talked about. So a few compliance tips I want to leave you with on this point particularly when we're talking about telehealth or new partners, do some due diligence, right? Like, don't just assume, if it's too good to be true, it might be too good to be true. You really need to understand where your specimens are coming from. Don't just say, oh, that sounds great, this marketer's going to be able to bring me 100,000 specimens. Stop, take a minute, do some due diligence, see where they're coming from, why they're able to transfer, whatever it is, but take some time to ask questions, understand who, the referring provider is, what their status is, make sure that they're not excluded from Medicaid, that, they're legitimate and they're able to, have this physician-patient relationship. And then you should really think about and should designate and sufficiently train employees to review your marketing material. Make sure that that's not causing questions about medical necessity. Again, vet those arrangements. You need to review your requisitions and make sure that they're not driving overutilization. And you really should think about reviewing and auditing the ordering habits of providers. We are hearing more and more from the government that they expect that you have an understanding of how many tests, right? So like, if a provider is ordering a test a day on a patient, you need to stop and think about that. Or if they're ordering UTI tests 4 times a week on a particular patient, like, that just doesn't necessarily make sense right off the top of your head. You need to think about how often and really understand those ordering habits instead of being flagged for high utilization and being sucked into the whirlwind of an investigation. And then you need to understand, the medical records. Yes, you can rely on medical necessity determinations from the provider, but that doesn't absolve the lab from all responsibility. So, one of the best practices tips is make sure that there are really good documentation notes that if you were audited or if there is an investigation, that the doctor is taking the time to write notes and then also follow up with the patient to say that, hey, this patient received the results, we talked about it. Because one of the big concerns that's going on right now from the government's perspective is that the patients don't know that there are tests being run. So these are a couple things for you to think about, and I'm going to turn it back to Ed.
Thanks, Danielle. And those are great compliance tips, and we're going to come back to the subject of compliance in just a few minutes. But before we do, let's talk about how you respond to these different investigative measures. These are the 4 we talked about earlier. And we're going to start with that moment when the agents are in your lobby. And keep in mind that when you're the one who's got to go out and talk to them, you want to be thinking about, how do I demonstrate credibility and integrity and professionalism? You've all heard the saying, you don't get a second chance to make a first impression. The agents are people too. They're trained to observe body language, verbal tics, things like that. So they're going to be watching you, and you're going to be their first real interaction with the company. So you want to demonstrate that this is probably a lawful, law-abiding, professional organization. So what do? As soon as you get that call, you don't mess around. You don't finish up that thing you're working on. You don't finish up the other phone call that you've got or the meeting that you've got. Just head right out to the lobby. Bring a notepad and a pen with you, and I'll come back to why that is in a moment, and bring a business card as well. As soon as you're out there, you want to direct the agents to a private area that's close to the lobby. In other words, you don't want to walk them through all the office space so they can see everything and overhear conversations and the like. Hopefully you've got a quiet private area that you can quickly kind of get them off to. And ideally, as I say here, it's a room with a table that you can sit down and if you have to, take notes, or just have it be a sort of more relaxed setting so you're not all standing face to face there in a hallway. So now this is not applicable when there's a search warrant. As I mentioned earlier, that's a completely different animal and requires a completely different approach, which I'll talk about as well. But so this is just that informal request that they've come in for. So what do you say to them? You come in and you want to be professional. Say, thank you for coming in. You introduce yourself, give them your title, and ask how you can help them. That's not a commitment to actually helping them and doing anything. It's just a great way to sort of break the ice and show that you're professional. And they'll give their explanation of what they want. And as I said, if you're sitting at a table, take notes of what they tell you. Don't write your impressions down. Don't say they asked for X. Oh, that's bad, obviously. Just write down as much as you can of what they're saying. And then when they're completely done, when they've gotten everything out, don't interrupt them. Don't give them any information. Just listen, get it all in, and write as much as you can of it down. And then just ask one more time, is there anything else you need? Now, typically they're there and they're going to say to you, well, we want to find out more about X and Y and Z and how you do this and how you do that. And we'd like to talk to these 2 or 3 people or something like that. But if they're asking for information and they're saying, can you give us these documents? What you say to them is what's right here on screen. Thank you for that explanation. This is important, right? You want to say that. You want to acknowledge the seriousness of the circumstances. You're not acknowledging that anything wrong was done. You're just saying 2 government agents came to our offices. Okay, this is important. Then you tell them our practice is to work with our legal counsel to respond to government inquiries. So I'm not authorized to provide you with anything today. And then you ask, if they haven't given it to you already, they should give you their cards when they first sit down with you, but sometimes that doesn't happen. Ask them for their contact information. Ask them when they're going to need this response by, right? Because they may say, we'd like to know A, B, C, and D. And you might think, well, it's sort of an open-ended invitation. You get back to them and you get back to them, but they're expecting you to respond the next day. So figure out when they want a response by. They'll typically say, and I'm sure everyone expects this, as soon as possible, but try to get a date out of them. Let them know you're going to get everything they've given, to counsel, and that, counsel, you're sure will get back to them promptly. And again, you if you have a business card you can give them, that's good. Otherwise, give them your contact information. Don't leave them hanging. Give them a point of contact, because you don't want them coming back the next day when you're out of the office for the day and they start talking to somebody else. So make sure that you establish that at least until legal counsel is involved, you're the point of contact. Now, in that moment, you may not know who the lawyer is who's going to help you, or even if ultimately there's going to be a decision to have a lawyer involved. But when they push you and say, well, who's that lawyer? Who do you work with? The answer is there in the next bullet. You can just say, I don't know exactly who it's going to be, but I don't want to give you the wrong name, and we'll get back to you. So the goal here, obviously, is to have this transaction end as quickly as possible and have you not share information with them. And I don't want anybody to think I'm sort of preaching this philosophy of, again, circle the wagons or don't tell the government anything. The reality of it is that when they're sitting there across from you, and you've got 2 agents, maybe with windbreakers and badges and guns on their hip, sitting across from you, there's a very difficult power dynamic happening. And I've seen over and over and over again, so many times more than I can count, people say the wrong things. I don't mean the incriminating things. I mean, they say inaccurate statements because they're feeling pressured, they're feeling nervous. And that's not great for the individual or for the company if you're so panicked that you're just saying the first thing that comes to mind. If you're going to provide information to the government in an investigation, you want that information to be thoughtful, considered, thorough, and accurate. And you just can't do that shooting from the hip in a hallway or in a conference room when you're shocked at 1:15 p.m. that these agents have come in and they want to talk to you. So it's perfectly acceptable in this informal setting for you to get yourself the time to make sure you can give appropriate responses. And so the next measure is obviously the CID, or the letter of the subpoena. And again, that's typically delivered by agents. And everything that I just went over applies in that same context. Now, I know it was a lot to remember that was on the other slide. So Danielle and I prepared a one-page handout that will circulate, or Alex will circulate after today's webinar. And it's the kind of thing you can kind of keep in your desk drawer. And it's a quick reference guide for exactly that kind of situation. But when those agents come in and they drop off the subpoena or the CID, do all the things that we just talked about. And there's a couple of don'ts on screen. Don't read the document in the presence of the agents. At a minimum, there might be something there that does make you very nervous. And when your eyes bug out and you gasp, that's just not something you want the agents to see. So don't read it in that moment. Even if they invite you to read it, say, no, I'll read it later. Thank you very much. You don't have to give them any information on the spot. Don't commit to saying, okay, great, I'll get you number 1, 2, and 3 tomorrow, and I'll get you number 4, 5, and 6 next week. You don't need to do that. And as I mentioned earlier, don't neglect to take it seriously. I would think no one would do that, but it happens from time to time. So then once you walk them out of the building, go back to that room, sit down and use that pen and that notepad, if you didn't take notes during the meeting, to write down everything that you can possibly remember, because it's going to be important for later. Your counsel will want that, senior management will want that. And then you get that document, whether it's a subpoena or a CID, to management ASAP. And please avoid talking about the subject matter via email, via text, via message. I've seen parties undone by sloppy text messages in the wake of this kind of visit. And the government has a good chance of getting it all. So you get that document to management, you get that document to counsel, and then you sit and you wait for guidance about what the right next steps are. Just briefly, formal interview requests. I've already explained what those are. This is one of those things you don't want to go in and talk to the government without counsel present. Same thing for a search warrant execution. Like, you operate in a highly regulated industry. While I hope none of you are ever on the receiving end of a search warrant, you at least want to have some idea about who the counsel is that you'll call in that moment, because there are things that lawyers can do for you in that moment. Things like helping you send all your employees home right away so they don't get interviewed by the agents. Being able to follow the agents around and track down what they do and what they take. You're allowed to do those things. The agents may also try to exceed the scope of the warrant, and you'll want counsel to walk you through that. So if a judge has said that there's instrumentalities of a crime, more likely than not in your offices, the stakes are so high that you absolutely want to involve counsel immediately. But so earlier, Danielle alluded to some compliance tips. In the last couple of minutes, we want to talk about ways to get ahead of the knock. Because if there's one piece of advice we can give you in this context, it's get ahead of the knock. Don't have the government show up and be unprepared for when they get there. And it's not just about knowing what to do in the moment and in the minutes after and the days after. It's really about what did you do in the weeks and months leading up to that knock at the door. And the government certainly expects you to maintain a culture of compliance. I'm just going to zip ahead to the next slide here. And you'll see this is an excerpt from a document that the DOJ has produced. And it's how they evaluate essentially corporate crime. And if you read that opening paragraph, you'll see that they refer to something called the Principles of Federal Prosecution of Business Organizations. It's basically the DOJ philosophy on how they prosecute business entities for crimes. And in that first paragraph, as you're skimming through it, you'll see that they focus on the efficacy of the corporate compliance program. If there's no corporate compliance program, or it's a piece of paper sitting on a shelf or a file buried somewhere on a computer that nobody really pays attention to and isn't robust and isn't effective and isn't tested and used, they're going to say you don't have a real compliance program. And then they're going to conclude that if you don't have a real compliance program, you're not really committed to compliance. In other words, you're trying to blind yourself from the possible violations of law that occur. And that's just a bad place to be in. And you can avoid that by having that culture of compliance, the cornerstone of which is a compliance policy that's thorough and is tested and is effective. And of course, at the heart of any compliance policy is having a designated compliance officer. Just imagine the scenario at your company if the receptionist is greeted in the lobby by 2 FBI agents and he or she doesn't know who to call and they call the wrong person. Well, having a compliance officer will make very clear that to the person you call. but it's also the day-to-day issues. Like you'll see under monitoring there, we have concerned or disgruntled employees. Those can be your worst enemy, those disgruntled or those concerned employees. Because if they don't think that there's a culture of compliance, if they think that corners get cut, if they think that senior management doesn't care, if they have no way to vet and raise their concerns, that increases the odds that they're going to go outside the building and they're going to share those concerns with a lawyer who brings False Claims Act cases, a private lawyer, or they're going to go to the government and become whistleblowers. So you need to have those measures like a compliance hotline that allows those concerns to be bubbled up to the one person who knows how to handle them, the compliance officer. But it doesn't end there. It's broader than that. It's operational. Danielle?
Thanks, Ed. The other thing that I talked about is that you want to understand and collect your claims data. You don't want to just be totally caught off guard. I think the worst position to be in is getting one of these informal or formal requests and have no idea what's been happening, right? Like you have no idea of your test volume. You have no idea, how many tests this provider is ordering. You just get really caught off guard and then are trying to backtrack, right? So, if there is a particular provider that is, not following guidelines, right? Whether it's an LCD or another payer or something, and they are ordering way too much, like you want to know that and take proactive steps to address that and educate and show that you're making an effort for compliance. And then you want to have a living and breathing compliance plan. Ed mentioned this, but you want to have documentation at the ready. So, you probably have this for, CLIA inspections, but, credentialing and licenses. But we've seen cases where someone's employed someone who doesn't have a license, doesn't have the proper credentialing, has been excluded from Medicaid. You need to make sure that those are done. You want to make sure that, the providers that are ordering from you are still in good standing, right? And like do periodic checks. The worst thing you could have to be in a position to find out later is that a provider that is ordering tests is excluded from Medicare or Medicaid, but is still sending you tests and you're billing for them, right? It's not a great position to be in. So you want to make sure that you have all of that. You also want to have education and training that you have taken compliance seriously. It's not just a plan that's sitting up on your bookshelf, completely collecting dust, that you've trained your employees, that you understand. It all goes to that culture of compliance. And you want to have at your ready key policies and that you've taken proactive steps, whether there's been an incident, whether you've done an investigation, whether that leads to a self-disclosure. There have been settlements where people should have self-disclosed and they didn't. And then the government comes in afterwards and says, you knew and you sat on it. And so those are all things that you need to be actively doing.
And last slide, because we do want to leave just a couple of minutes for questions. If I had to add a fourth common misconception, you remember the three earlier, I would add that the misconception is that compliance programs are expensive and they take lots of resources to implement and to use on a day-to-day basis. And that's simply not the case. Compliance policies are the kind of things that your counsel can draft up typically in a matter of hours, and then they can sit with you and work it out to make sure it's applied to your organization appropriately. And there's a bit of annual training you have to do, but it is not terribly onerous. And it's an expectation that the government has of you, and in some context, even a requirement that the government has of you. So, if you have one takeaway from all this, it's make sure your compliance policy is in order. And here you see on the screen there in the first couple of bullets, what the government expects your compliance policy to be able to do. Those 5 sub-bullets are, if it's not capable of doing that, if it doesn't expressly provide for those things, then it may be falling short. And Danielle alluded to the concept of self-disclosure. The government expects you to police yourself, and they expect you to come to them and say, this is the violations that we engaged in, but we've cleaned house. And that's obviously, you can have a whole seminar on voluntary self-disclosures, but just leave you with the thought that, we have seen, as Danielle mentioned a moment ago, plenty of clients and plenty of organizations that, have had some inkling of a problem, have seen the thread on the sweater, but haven't pulled it, and have sort of convinced themselves the government's not going to figure this one out. The government's not going to come after us. and then they were in for a pretty rude awakening after. At the same time, we've seen companies more often than not that have very robust and healthy compliance programs. And when those issues pop up, they're all over them. They investigate them, they understand them, they remediate them. Sometimes it's through discipline, sometimes it's through restitution, and they sit down with the government and say, mea culpa, we made a mistake. And while they don't always get amnesty, they more often than not will get leniency because they're doing what the government expects them to do. So with that, Danielle, I think we probably stop here and save the next couple of minutes for any questions that anyone may have. And Alex, do you have any questions that have come in?
Yes, we do. We have a few questions here really quick before we dive into those with the last few minutes we have here. Just wanted to push this offer that I alluded to at the beginning out. If anybody doesn't get a chance to have their question answered here today or just wants to follow up with Ed and Danielle in general about compliance or responding to an inquiry from the DOJ, go ahead and open up that form. You'll be able to provide some quick contact information and we'll get that over to them so that they can respond to you. And then just additionally, really quick here, we at Lighthouse also have a compliance offering for labs. And if you're interested in any of the general services, recruiting, staffing, RCM, payer strategy, anything else that I mentioned in the beginning, go ahead, feel free to open up that form and we'll be in touch shortly. But to hop into questions here quickly, one that we have here, and I think this is going to be a pretty general question, but Maggie's asking, what type of counsel should a lab look to have on retainer? I bet that's probably pretty organization specific, but are there any tips you can offer there?
Danielle?
Sure, I would say, just make sure that you have a healthcare attorney. I've heard a lot of labs just have business attorneys, and while they're, competent to, give you transactional advice and things of that nature, there are nuances that healthcare attorneys spend a lot of time focusing on with dealing with the myriad laws. So I think it's a good idea, just because you're in such a heavily regulated environment, that at the very least you have, a regulatory attorney to ask questions to, and then, they can also connect you with people like Ed, if, the government ever did come knocking, and, be able to be there as kind of a first stopgap.
Thanks, Danielle. This is a bit of a broader one, but I think it's a good distinction to make and to end on here today. Could we talk briefly about the difference between a commercial payer investigation versus a government investigation, and maybe kind of what you may legally be required to respond to there?
Danielle, do you want to start that? Maybe I'll finish that one.
Sure. So, I think that they do look different. I meant the commercial payers will, cite federal and state laws. They will send generally very long letters. You might get just audits saying, we're refusing to pay, we have concerns about fraud and abuse, this has been referred over to payment integrity, which is, then you need to follow the commercial plans appeal process and go through that. Sometimes they're willing to talk to you, sometimes they're not. But, in some circumstances, commercial payers will send you a very threatening letter, very long. Often it's generally much longer than what you see from the government, sounding very threatening, being, making all of these allegations about fraud and abuse and compliance, and that you're not following their plan. One of the first things you want to do is, if you are in network, pull your in-network contract. If you're out of network, which most, a lot of labs are, you still want to understand what their payer policies are, and, start looking at that, and then have that claims data, and so I think that there's differences because they don't have all of the resources and, things like CIDs and search warrants, but they have their own investigative process that's often outlined in their policies and procedure manuals. And a lot of that is that they can exclude you, from participation or just withhold payment. So Ed, do you have other thoughts on that?
Yeah, I'll contrast that with the government investigation. Obviously, in a government investigation, government enforcement investigation, the stakes are much higher because you could be dealing with concepts like debarment, imprisonment, multipliers of penalties, such significant outcomes. But beyond that, the tools that the government has are so much more invasive than the commercial payers. But I guess the third thing I would say is that with the commercial payer investigation, that you've got it's very clear what their issues are, what their concerns are. So you know what they are, they're targeted. You can kind of go down that path of addressing them. When you have a government enforcement investigation, they don't come down and say, here are 2 or 3 or 4 or 5 concerns. They simply show up and say, give us information. So you don't know exactly what they're focused on. And sometimes where they start isn't where they end, and where they end can be very far afield of where they start. That's why it's so important to be, very responsive and very on top of that government investigation, and to monitor as it progresses. But great question.
Yeah, and thank you both. Great answer. Great detail there. All right, we're bumping right up against 1 o'clock here. So just one last time, if you didn't get a chance to talk to Ed or Danielle or have your question answered, feel free to fill out that form there and we'll get that over to them. But otherwise, I just want to quickly say thank you again to both Ed and Danielle for sharing your expertise today. I think it was a great subject to touch on, and we had a great audience. So thank you again.
Thank you, Alex. Thanks, everyone.
Yep.
Thanks, everyone.